See if they need more time and they're ready to go. Just bring them. Good morning. Holding up okay?
Thank you. Take your car over, please.
Neil? I have to do a call for you.
Oh, for now. No, that's why I'm sorry. Sorry. I was one step behind.
All right, Neil, I'm going to step off. As soon as we're ready to go, just come get me.
Here we are. Second. All right, remain seated for the press.
Okay, you may be seated. We ready to continue?
Yes,
Okay, we ready for the colloquy?
yes, Your Honor.
Okay. Mr. Dippolito, I'm going to ask you to raise your right hand for me. Do you swear or affirm the evidence you're about to give is the truth, the whole truth, and nothing but the truth? Okay, you may put your hand down. Just for the record, go ahead and state your full name for me.
Dalia Dippolito.
All right, Ms. Dippolito, what I'm going to do now is I'm going to talk to you about your right to testify in the case or not testify in the case and find out whether for yourself you've made a decision. So the first thing I want to do is start with your rights, make sure you understand them. In this case, you have the right to take the stand and testify as any other witness, or you have the right not to testify, and if you exercise that right, the jury is not allowed to consider that or infer guilt from the exercise of that right. So my first question to you is, do you understand you have these rights? Do you testify or not testify in the case? Do you understand that?
Yeah.
Okay. Now there are certain decisions that your attorney gets to make for you. Those are called strategic decisions. Certain decisions, however, are fundamental, which means you have to make the decision yourself. The decision to testify or not testify in a criminal case is a fundamental decision, which means you for yourself must decide. Do you understand that? Okay. Now, do not tell me what you spoke to your attorneys about, because that is privilege. I'm not entitled to know about that. I just want to make sure you've at least had the opportunity to speak to your attorneys concerning whether to testify or not testify in the case. Have you had that opportunity and chance?
Yes, I have.
Okay. For yourself, have you made a decision about whether you wish to testify in this case or not testify?
I have.
Okay, and what is that decision?
I'm not going to testify.
Okay, you're going to exercise your right not to testify. Very good. I'm going to instruct this jury that they cannot use that in any manner whatsoever. Thank you, Ms. Dippolito. Okay, so defense, when the jury comes back out, the defense is now going to rest. Is that correct?
Yes, Your Honor.
Okay. Mr. Williams, is the state ready to proceed with the reopened case?
We'd like to do the rebuttal case first with Ms. Slater, and then we would like to finish with the reopening.
Okay. Is there any further discussion about the rebuttal case before? The rebuttal case, as I understand it, is the publication, the admission and publication of the additional video. Is that right?
Yes.
Okay. Any further discussion about that?
Yes, Your Honor. We had filed a motion to exclude them from playing the state crime scene.
You mean the original motion or a new motion?
We had filed a new motion, gave you a copy on... Actually, no, I don't know if we gave you a copy.
I don't recall seeing a new motion. I remember seeing the old motion.
I never read
May I approach, Your Honor?
Yes.
I apologize. I need to discuss.
Has the state seen the new motion?
I'm a copy right now. It's very brief.
Okay. Basically 3 points, which I believe I've heard before, but go ahead.
Because last week, Your Honor, you did not rule on whether or not you were going to allow them to introduce the video. You deferred ruling.
Right.
All right, and we just have 3 arguments. First, it was the state that initially put the staged crime scene video at issue. When they were questioning in their direct examination Detective Moreno, they went into Detective Moreno going to Mike Dippolito's house, confronting him. So for them to say they're prejudiced by not being allowed to play the video now is somewhat disingenuous. I mean, they opened the door, they created that prejudice. Secondly, Your Honor, the testimony elicited is in no way misleading to the jury or unfair to the state, and that's assuming Mr. Claypool, through his examination of Stephanie Slater, did in fact refer to the staged crime scene, which we still deny. It's our position that Mr. Claypool was referring to other videos. He never referenced staged crime scene. In questioning Detective Moreno, he never mentioned staged crime scene. And third, this court previously held in the motion in limine that the vast danger of unfair prejudice outweighs whatever slight probative value the staged crime scene might provide. And just a couple other points, if I could have one moment, Your Honor. And it's referring to Siegel v. State, 68 Southern 3rd, 281, that's out of the 4th DCA, 2011. And that explains the evidentiary concept of opening the door, and that allows the admission of otherwise inadmissible testimony to qualify, explain, or limit testimony or evidence previously admitted. This principle is premised on considerations of fairness and the truth-seeking function of a trial. And in order to open the door, the witness must offer misleading testimony. or make a specific factual assertion which the opposing party has the right to correct so that the jury will not be misled. The mere fact that there was a camera crew from cops, which Your Honor more or less mentioned when initially speaking to the jury pool that cops was involved in this case, is in no way a factual assertion that misled the jury. It's not misleading testimony. There's no specific factual assertion that the state needs to correct so that the jury will not be misled. Assuming you do not believe Mr. Claypool's assertion that he was referring solely to the other videos in this case, which are also put on YouTube, which is our contention, nothing needs to be corrected. And the fourth, I believe, and I'd also point your attention to Bozeman v. State, 698 Southern 2nd, 629, stands for that proposition. Further, Judge, even if you find that we did open the door, and as I previously argued, the state initially opened the door, so for them to argue now that their prejudice is very disingenuous, but even if you found that we did open the door, Your Honor has the discretion to still exclude the evidence if the probative value is outweighed by the danger of unfair prejudice. And it's our contention that without question there's unfair prejudice by this theatric, and I'm using Your Honor's words, crime scene that has no place in law enforcement and no place in an investigation. One moment, Judge. Further, as we stated, it was the state that initially opened the door. The defense adduced no testimony that would mislead the jury. Mr. Claypool asked Ms. Slater whether a video that cops in the Boynton Beach Police Department both filmed was posted on YouTube immediately after the filming on August 5th. He didn't go into the contents, and this is assuming you believe that he did refer to that video. He did not discuss the contents of the video. He didn't discuss that this staged crime scene was set up. He just said that was the first time that Boynton Beach went to, or probably he didn't even say that. He just said that there was cops on scene and that was released by Boynton Beach Police Department. There's no content that came out through any testimony. Now, had content come out through Ms. Slater's testimony, which could potentially mislead the jury, then the state might arguably, and I still think there's a 403 argument, but they might arguably have an argument that the jury was misled. But in light of the fact that absolutely nothing about the content of that tape came out, about the substance of the video was relayed to the jury. There was no mischaracterization of the video. The colloquy clearly described a video that was shot both by cops and the Boynton Beach Police Department. And Ms. Slater herself testified, and she said it about 4 or 5 times whenever she had the opportunity to interject, that it was filmed on a public street where no one had any reasonable expectation of privacy. And I think given the clarity of that context, there is little, if any, likelihood that the jurors would confuse the staged crime scene with any other video at issue in this case. And there are other videos that are at issue in this case. So in the absence of any unfairness to the state, and I see no unfairness to the state, it's difficult to see how the introduction of this video would serve to qualify, explain, limit the prior testimony. And finally, Judge, as I stated before, the unfair prejudice is so great in this case with this video. It's so theatrical. No one's been misled. And to play this would necessarily violate Ms. Dippolito's state and federal due process rights. And in the alternative, if Your Honor were to deny our motion and allow the state to play this video, we believe it's necessary that you play the entire video, which is not just Ms. Dippolito arriving on scene and crying, to establish proper context and conformity with the rule of completeness. Your Honor would have to play the video that was aired on Cops, where they show former Sergeant Ramsey, and the other detectives from Boynton Beach Police Department actually constructing the crime scene, directing people where to go, manufacturing this crime scene. That's necessary to provide context. Because if you believe we opened the door, it would have been open for the purpose of manufacturing this crime scene for future publicity, and the whole context has to be shown to the jury, not just a limited portion.
Ms. Lord.
Judge, to kind of go through and respond to the different points that he's made in the motion is, first of all, the state does not believe that they opened the door through Detective Moreno. Detective Moreno was not questioned about the staged crime scene. Detective Moreno was not even present for this staged crime scene. He testified that he went over to Mike Dippolito, notified him, took him to the police station, and he was never present for this. So I believe that, to my recollection, that is inaccurate. As far as the questioning of Ms. Slater, she was questioned by Mr. Claypool. And isn't it true that 6 minutes after this happened, you posted this video on cops? And she said, no. And he said, well, you saying you didn't post it? And she says, no, it was a few hours after the fact. So they get into this back and forth of time period. And to say now that he was talking about the surveillance video when the entire conversation is about her saying that this is a video that was taken on a public street, that people could walk up and video exactly what was happening, I don't think that you could ever construe that that was the only other video which would have been with the undercover agent, which was not obviously on a public street. It was in a car. I mean, it was in a parking lot, but it's clear that I think from the questioning he was asking of her that it was in direct reference to this staged crime scene video. I guess to go through this, Judge, they've made a big deal through questioning of Ms. Slater of how wrongful it was to have cops present, that it compromised an investigation, again leading back to this entrapment that Boynton Beach, to go to their opening, Boynton Beach Police Department was a department that went rogue, who was so worried about constructing a fake crime scene and facilitating this entire thing and having this on cops. This is the entire feature of their defense and of their case. And I think, you know, it makes it important for the state to be able to then bring this out, because they brought all this out through their witnesses and through their expert of how it was wrong to do that and that compromised an investigation, for the state not to then be able to get up and explain exactly what this was and to show exactly what was going on, to not allow the state to display the contents of that makes it, I think, prejudicial to the state. They make it seem as if the state's withholding evidence, hiding evidence of some sort. Again, for them to say that it compromised an investigation, I think a jury should get to see that, to see, does it compromise an investigation in their opinion? I think it's probative to the state in those situations. In addition to that, it shows her intent to have this crime committed. It shows her further intent in the way she acts. They've questioned multiple witnesses on a potential allegation of domestic violence by Ms. Dippolito, and that was part of the reason that Mr. Shihada went to the police department. So in that situation, it's important to have this to display her demeanor as she's being notified of this happening, to couple with the allegation of potential domestic violence. And they get to theatrics. I don't think it's fair to come in here and say, well, Judge, you said that part of this was theatrics, so therefore it should be excluded. The only theatrics, honestly, that I see in this whole thing, I mean, yes, is cops standing there videoing it? Yes, but the person who is being dramatic is the defendant. She's the one screaming and crying. That's the theatrics of this video. It's not the police or anything else. I think that they clearly opened the door to allowing the state to explain or show a video of exactly what they're talking about when they're accusing witnesses of posting this video online, and that was improper and basically compromises this entire investigation. To not allow the state to put this in then prejudices the state.
May I respond, Your Honor?
briefly. I've been thinking about the issue. I don't need a lot more, but go ahead.
Just 3 quick things. What your court did state was, what your Honor did state, I apologize, was that the staged murder scene was of little value to the investigation because the crime of solicitation, if occurred, was complete when the defendant asked the undercover officer to assist in the murder of her husband. Secondly, the content was never put in question.
I then said it wasn't without complete value.
Correct. But you are, in doing that, you are saying it has minimal probative value and there is unfair prejudice. Or that's my...
Well, I didn't say unfair prejudice. Unfair prejudice wasn't an issue on the motion.
That's my interpretation of your Honor referring to it as theatrical and... But moving on, Your Honor, the content was never put in question, and more importantly, the jury has absolutely no idea what video she's talking about. We sat here for 15 minutes debating back and forth trying to figure out what video Miss Slater was talking about. If Your Honor, myself, Miss Lori, Mr. Williams, Mr. Claypool, Mr. Greenlee can't figure out for 15 minutes what her testimony was about and what video she was referring to, then for the state to indicate now that they're prejudiced is asinine. It makes no sense. It makes absolutely no sense. It was such a small point. The only point had to do with a party, the fact that a video, regardless of what it was introduced, and that is in direct violation of Boynton Beach policies and procedures. That was the only point made, and no one in this courtroom could figure out what video was referred to. The jury has no idea what they're talking about, and now we're telling them. And the risk of unfair prejudice is so great in this situation.
Okay. Defense objection is overruled. The analysis is actually fairly simple. It does not turn upon exactly what Mr. Claypool was referring to. It turns upon the following. A defense feature and theme of the case, not just with the witness in question, but with respect to all witnesses, has been that somehow the publishing of a video on YouTube has somehow prejudiced the defendant. That's the constant position that's been taken with regard to questioning of multiple witnesses, including the expert witness who just testified. So it's been a feature of the defense case. Because it's been a feature of the defense case, the state has the right to put that video into evidence, show it to the jury, and then in our closing argument say this didn't have anything to do with and did not prejudice the presentation of the defense case. It's really that simple. On the 403 analysis, in the case in chief by the state, 403 may have precluded its admissibility. In other words, I never actually ruled on that. That was agreed to by the state. But given it had minimal value with respect to the actual crime committed, but not no value, it is possible on a 403 analysis in the case in chief, the risk of unfair prejudice would outweigh the probative value. But it's a different 403 analysis now that it's become a feature of the defense case. They're entitled to put it on and say, is this what you posted? Whatever it is this what you posted? Yes, show it to the jury and then argue this is what we posted and it didn't in any way prejudice the defendant. And so I think it's clearly admissible in rebuttal, and that's my ruling. Or do we have, how long is it going to take to put this thing on? I've had this jury.
I have Ms. Slater in the hallway to, obviously I would just be putting her on YouTube, and she's already reviewed it. I've already had her initial it, stating that she's...
So she's simply going to testify, this is what I posted.
Yes.
YouTube
then,
or wherever you post those such things, and then the
Marino.
tape can't be that long.
No, it's not too long. And then Detective Marino is in the hallway, I believe.
Take a little longer.
All right, well, that we'll do after lunch, but I'm wondering whether we can get this done before the lunch
Yes,
break.
this is what-
Okay.
I'm going to get it all queued up and ready to go, Judge.
Okay.
Your Honor, one point of clarification from our end. I take it I will be allowed to ask now what went into state crimes.
Depends on what the direct is. I mean, perhaps. I mean, I haven't heard the direct yet. I mean, I'm going to have to make that ruling after I've heard the direct and see if it's in the scope.
And I'd raised one other issue, I'm sorry. That one I'll address it before, Judge.
Right when you were trying to speak, that computer...
I guess the other point I'd raise to the court in the alternative, if Your Honor had in fact allowed this recording to come in, that the state be required to play the entire recording, which includes the police officers setting up this staged crime scene.
Yes. I am prepared to rule on that if you're asking.
The rule of completeness would require, it shows the actual theatrics of law enforcement setting up this staged crime scene.
Did she post that?
That was posted by cops. That was
Did
played
she
by
post
cops.
it? Okay, if she didn't post it, the only reason it's coming in rebuttal is because a position has been taken by the defense that what she posted somehow prejudiced the defense. Okay, that's the reason I'm ruling it can come in. So what she posted is all that will be played. What she posted is what's at issue, and the question becomes, by the posting by the Boynton Beach Police Department, did that in some way prejudice the defense? So only what she posted would come in.
Actually, Judge, real quick, she testified, if I'm correct, that she never posted the video, that somebody else posted the video.
That's incorrect. She posted it. I'll call her. You can
All right,
see
well,
it.
she's going to testify. She doesn't testify to that. She doesn't testify to that. I mean, you cross-examined her extensively on that.
Yeah, Judge,
I mean, I think
before the
even
jury
if
hears that, we need to. She testified directly. Mr. Claypool asked her, and she said,
Your Honor, I'm sorry.
I think what you're saying is she may have had it posted by her IT people, but she was the one that directed it to be posted. Whether she physically did it herself or whether she had it posted by an IT person is of no significance. The issue in the case, from the defense perspective, has become the Boynton Beach Police Department posted this video. This video somehow caused prejudice. Therefore, whether she posted it personally herself or whether she said to her IT person, please post this for me, is of no moment with respect to my ruling. It doesn't really matter. What matters is what did the Boynton Beach Police Department post? Okay, that's the issue.
yes, Your Honor. And the last thing I'll say, I don't know if I mentioned in my argument, was Mr. Claypool never used the term staged crime scene. But
I know, but my ruling doesn't rest on what, I think Mr. Claypool was as careful as he could be as a lawyer. My position is it doesn't turn upon the question he asked. It turns upon the fact that this is a defense theme. It's been asked of numerous witnesses, so they get to put it on and say, this is what I posted, and the jury can decide by the posting of that, did the Boynton Beach Police Department somehow, I guess, affect the investigation, or should it not be considered as credible evidence? Are we ready to bring this jury in? Okay. Let's go ahead and bring the jury in. We'll get this done, and then I'm going to let you rest in front of the jury, okay? So I'll ask, does the defense have any more evidence to present?
Jury entering.
All right, counsel, you may be seated. Welcome back, ladies and gentlemen. I realize my statement about being 5 minutes has no credibility with you at this point, and I do apologize. So I took a little long. Any additional? Defense rests. All right. State is asking for rebuttal evidence. Is that correct?
Yes, sir.
You're ready to proceed with your first rebuttal witness?
Yes, sir.